Hello, my name is Stephen Meyer. I'm a student here at Northern, and I'm a member of the Student Government Association on campus as well. And we're going to be considering a bunch of resolutions concerning the bills that you guys are considering over the next couple of weeks. And I was talking to a buddy of mine, and we came upon a cross of confusion. And any of you senators could maybe clarify this. It's so there's Senate Bill 38, which is the constitutional carry bill. That's something that you guys are discussing, but then there's also Senate Bill 47, which, from what I could tell, basically does the same thing. And if you guys could maybe clarify what the difference is there, that would be pretty helpful.
Thank you for the question. I was the Senate Prime on Senate Bill 47. I had talked behind the scenes with some of the interested parties in Senate Bill 38, and they said that they actually, at this point, like my bill better, but they're sitting on it, seeing what happens with Senate Bill 47. So the bill that I brought most closely reflects or mirrors what was brought in 2017 that passed the legislature and was then vetoed by Governor Dugard. It requires a lot of discussion as to what it does to be thorough, but I will just simply say this. In South Dakota, we are an open carry state. So in venues where it's not a gun-free zone, where the property owner hasn't declared it a gun-free zone, a person can carry openly. So if I didn't have a jacket on and I was walking along with a gun on my side or what have you, I would be legal. So long as I wasn't subject to one of the disqualifying factors, and there are 10 in South Dakota law, and there are 7 or 8 in federal statute. There are many things that do limit a person's ability. Of course, they're within reason. If I'm a felon, I can't possess. It's illegal for me to carry openly or concealed or any other way. It's illegal for me to possess a weapon. If I'm mentally ill, illegal for me to possess a weapon. If I'm habitually drunk or habitually intoxicated via druggedness, I am not able to possess legally. There are other things. If I was dishonorably discharged from the military, that is a limiting factor. So really, what we're dealing with is the question as to whether if a person slips a jacket over the gun, or puts the firearm in a purse or tote, or slips it under the seat of his or her car, if that should be illegal without a permit for those law-abiding citizens. The bill doesn't change anything as to what the limiting factors are. All it says is that if you are a law-abiding citizen, not otherwise prohibited from having a firearm, you no longer would have to go to the sheriff's office and submit to the permitting process to carry in South Dakota. However, this doesn't repeal the permitting process on any level, neither the basic permit, nor the gold permit, nor the enhanced permit, because each of those affords people reciprocity with other states. And so in a lot of cases, I would probably argue most cases, people will continue to go through the permitting process. But for those people who don't anticipate traveling outside the state anytime soon, what have you, for which reciprocity is not a concern, they may choose to go the permitless route, or as some people call it, the constitutional carry route. I very much see the continued need for the permitting process, though, because of how mobile we are and how many people want to travel outside the boundaries of our state and have their firearms privileges recognized in those other states. I did hear one story. A lot of people have their concealed carry permits expire, and they pull out their wallet or their purse or what have you and discover, oh my goodness, that expired 2 months ago or 2 years ago. In one case, a lady had gotten into her husband's car, and she was traveling down the road. He had a firearm between the door and the seat, apparently, and she was just completely oblivious to it, not thinking a thing of it. Well, she got stopped, and obviously when she opened up the door, as the officer invited her back to the car, he saw the firearm and asked her for her concealed weapons permit. She didn't have a valid one, as it had expired, and she was prosecuted to the fullest extent of the law. So essentially, a law-abiding citizen otherwise was criminalized. The behavior was criminalized and was really an honest mistake on her part, a complete oversight on her part. So we're trying to get at that. We're trying to uphold the spirit of the law for law-abiding citizens, and allow those people to equip themselves to put down a threat if a bad guy, so to speak, does possess a firearm. And we're not, as I said in committee, and as I've said a couple times in interviews, this isn't about making South Dakota the Wild West. There are 11 other states with bills or with laws in place similar to this. There are others with different restrictions or limiting factors, but a number of states, 15 to be accurate, have enacted some sort of permitless carry over the past few years. Thank you for the question.